Okay, let's jump right into this explainer. Look, if you've ever stared at a literal mountain of scribbled case laws and complex statutory provisions and thought, how on earth am I going to remember all of this for the exam? Well, you are in the right place. Today, we're taking a super dense set of handwritten legal notes and we're transforming them into your ultimate visual study guide. We're talking sections 14 through 25 of the Hindu Marriage Act. It's going to be efficient, structured, and honestly, crystal clear. To get us there, we've broken things down into four main thematic buckets. 1, filing timelines and jurisdiction. 2, remarriage, bigamy, and legitimacy. 3, trial procedures and protocols. And finally, 4, alimony and financial maintenance. Having this mental filing cabinet is an absolute game changer for your exams. And just so you know exactly where this is coming from, we're pulling our insights straight out of these original, highly detailed study notes. This is raw, unfiltered legal knowledge. We're going to pull out the exact case laws and those sneaky statutory traps hidden in these pages, so you've got exactly what you need to snag top marks. All right, let's kick things off with Section 1, Filing, Timelines, and Jurisdiction. Let's build that foundation.
So if you get a question on jurisdiction under Section 19, you really want to use this core framework to anchor your answer. Normally, the rule is you file where the marriage was solemnized, where the respondent resides, or where the couple last lived together. Simple enough, right? But here's the classic exam trap, the exceptions. A petitioner can only file where they currently reside under very, very specific conditions. For example, if the respondent is living outside India, or if they just haven't been heard from in 7 long years. Basically, it's a legal safety net for a spouse whose partner has practically vanished into thin air.
Now, moving on to Section 14, which hits us with a very strict rule. No petition for divorce before completion of 1 year of married life. And, this isn't just some administrative red tape. It's a mandatory statutory cooling-off period. The law literally forces a breathing period just to prevent these impulsive, heat-of-the-moment divorces right after the honeymoon phase fades. The court basically wants to say, hey, is reconciliation possible before just letting couples rush straight to the courtroom? But of course, the law always has exceptions, right? Like cases involving exceptional hardship or depravity. But beware of this major exam trap. If an exception actually applies, you can't just file your divorce petition early and sort of vaguely mention the hardship in the paperwork. No way. The recent 2024 Alka Saxena case makes it super clear. A completely separate application seeking the court's leave, which basically means permission, has to be filed first. You have to formally ask to bypass that 1-year bar before you even think about introducing the divorce petition itself. So definitely do not let that procedural hurdle trip you up. Moving right along to Section 2, remarriage, bigamy, and legitimacy. Okay, so the absolutely crucial point here is that you cannot rush into a second marriage. Under Section 15, you literally have to wait for the appeal window to be completely and totally extinguished. Just look at the tragic legal trap in this 2022 case, N. Rajendan versus S. Volley. Someone got remarried exactly 30 days after their divorce decree. Sounds fine, right? Except the wife had filed an appeal. The court actually voided that entire second marriage. And why? Because the Act calculates the time limit for an appeal from the date the certified copy of the judgment is actually obtained, not just the day the judge bangs the gavel. So if you jump the gun, your new marriage is void ab initio, void right from the starting line. And honestly, this brings up a huge point of confusion for a lot of students right now. Under Section 17, we deal with bigamy. Now, we all know the landmark Joseph Schein case in 2018 famously decriminalized adultery. But listen carefully. You must explicitly state on your exam that bigamy remains very much a punishable criminal offense under Sections 494 and 495 of the Indian Penal Code. You cannot conflate the two. The law might not throw you in jail for cheating anymore, but it will absolutely punish you for marrying a second time while that first marriage is still legally active. Speaking of punishment, let's talk about the super recent 2024 Babar Narayan Prasad case. Here, the Supreme Court actually weighed in on the sentencing for bigamy, and they adjusted the punishment down to 6 months. The court highlighted a really powerful principle here: proportionality. Basically, the sentence shouldn't be so ridiculously harsh that it completely ignores the messy reality of a broken relationship, where a divorce was already pending. But on the flip side, it also shouldn't just be a mere flea bite. The law demands a balanced, proportional consequence. Which naturally leads us to a highly tested and frankly pretty emotional area of the Act:
What actually happens to the legitimacy of children if their parents' marriage is declared completely void under Section 11? It's like this tragic crossfire of annulled marriages. The law really has to walk a tightrope here, balancing the strict legal invalidity of the marriage with the absolute innocence of the child who was born into it.
So the answer is found under Section 16, and it was beautifully clarified in the Ravana Siddhapa case back in 2011. The law grants the child what we call limited legitimacy. It's a really fascinating compromise, actually. Even if the marriage is technically void, the child is still legally legitimate. They are absolutely entitled to inherit their parents' property. However, and seriously underline this in your notes, they cannot claim co-parcenary rights in the wider ancestral estate. So they get their parents' share, sure, but they don't get a seat at the extended family's ancestral table. It's a smart way to protect the child without completely tearing up traditional property laws.
All right, shifting gears. Section 3, Trial Procedures and Protocols. Now, timelines are absolute gold for any exam recap, so you really need to lock down these 3 critical statutory deadlines, which were basically designed to stop family disputes from just dragging on for decades. First, Section 24 maintenance applications, those should be disposed of within 60 days of notice. Appeals, they should ideally be totally wrapped up within 3 months. And the actual trial itself? Well, the court is directed to try and conclude it within 6 months from the date the petition is served. The entire goal here is speed and certainty. But hey, speed doesn't just mean rubber stamping things. Before a judge grants any decree under this act, you need to show the examiner that the judge is statutorily bound by Section 23 to run through a very specific checklist. First, the petitioner cannot be taking advantage of their own wrong. Second, there must be no condoation, which basically means they didn't forgive the bad behavior and then suddenly change their mind later. Crucially, there can be zero collusion between the parties to fake a ground for divorce. And finally, no unnecessary delay in filing. The court absolutely must be satisfied on all these points before granting any kind of relief. And remember, at the end of the day, family disputes are intensely private. To protect that, Section 22 strictly mandates in-camera proceedings, so closed-door hearings. If someone unlawfully publishes those private details without permission, they're going to get hit with a 1,000 rupee fine. Now, sure, that amount might barely buy you a couple of coffees today, but the statutory principle here, guarding marital privacy, is still a massive deal.
Finally, let's bring it home with Section 4, alimony and financial maintenance.
You've got to make sure you emphasize this in your exam. Section 24, which is also known as pendant light, is strictly for temporary maintenance. It only applies while the legal proceedings are actually ongoing. And here is a really vital point you want to highlight. It is completely gender neutral. It's available to either the husband or the wife as long as they can prove they don't have enough independent income to support themselves or, cover those hefty legal expenses.
If we look back at our source notes, you can see how the statute makes this really elegant transition. It moves seamlessly from managing those immediate, temporary, monthly expenses in Section 24 straight over into the heavy mechanics of permanent, final decrees in Section 25. Honestly, contrasting these two sections is just an easy way to score major points. Think of it like this. Section 24 is a temporary lifeline. It's usually a monthly sum just to keep a party afloat while the court is still deciding the case. But Section 25, that's permanent alimony, awarded at the time of the final decree. And unlike 24, Section 25 can be a massive lump sum, or periodic payments. Plus, the court heavily weighs the total property, the income of both parties, and, this is key, the actual conduct of the parties during the marriage. So as you wrap up your studying and really master these sections, I want you to consider this final thought. We've just looked at all these strict timelines, mandatory checklists, and really rigid financial rules, right? But while these provisions absolutely provide a much-needed legal structure, how effectively do they actually manage the messy, deeply human, and chaotic realities of a broken marriage? Just keep that in the back of your mind as you're writing your exams. The law is incredibly structured, but the lives it governs, yeah, they rarely ever are. Best of luck with your studying, and I will catch you in the next explainer.